25, tier 3 is lifetime, but you can petition after 25 if you haven't gotten in trouble.
Okay. All right. So, all right. This is in the matter of people of the state of Michigan versus Jeffrey Lee Kapnick, file number 24-21720FC. I have Michael Dagger Margosian appearing on behalf of Mr. Kapnick. Mr. Kapnick and his attorney are present in person today. I have Phoebe McClure appearing on behalf of the Illinois Prosecutor's Office. She's in the building, but she is appearing from Zoom from her office. This is a date and time set for a plea. Mr. Dagger Margosian, I have received a plea agreement form as well as an amended felony information. You received those?
Yes.
All right. The plea agreement form states that the defendant agrees to plead guilty to 2 counts of CSE 4th degree, which on the felony information are count 3 and count 4. Count 1 and 2 would be dismissed at the time of sentencing. And additional terms are that he will be required to register by statute as a tier 3 sex offender registration act offense, which is lifetime registration, but if he never gets in trouble after 25 years, he can petition to be removed. Is that your understanding, Mr. Dagger Margosian?
Yes.
All right. And I don't see any other terms of the plea. Am I missing anything in the agreement form?
No.
All right. Mr. Kapnick, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
That's right.
All right, Mr. Dagger Margosian, can you move the mic between the two of you a little bit? Okay, good. Sir, can you state your full name for the record?
Jeffrey Lee Kapnick II.
All right, so Mr. Kapnick, you've had a chance to read and review the plea agreement form?
Yes, Your Honor.
All right, and you wish to accept this plea offer?
Yes, Your Honor.
All right, and you've had an opportunity to discuss it at length with your attorney.
Yes, Your Honor.
Are you satisfied with your attorney and the advice that he has given you?
Yes, Your Honor.
Do you understand that the maximum penalty for count 3 and count 4, which are criminal sexual conduct 4th degree, could be up to, it is a high court misdemeanor. So the maximum penalty could be up to 2 years in prison and or a $500 fine.
Yes, Your Honor.
Is that right?
Yes.
Okay. You had that look on your face like
No,
I was saying
no.
something wrong.
Nope. No.
All right. And I do show that his DNA has been done and his testing has been done. All right. So other than the plea agreement form I have in front of me, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Dagger Margosian?
Correct.
And Ms. McClure, is that correct?
That's correct.
And Mr. Kapnick, is that correct as far as you're aware?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. And you fully understand the requirements and that by entering this plea, you will be required to register under the Michigan Sex Offender Registration Act.
Yes, sir.
Okay. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. So the appropriate response to the next 2 questions would be guilty or not guilty. Do you understand that?
Yes, Your Honor.
All right. So, Mr. Kapnick, how do you wish to plead to the charge listed under count 3 criminal sexual conduct, 4th degree, that on or about the time period between December 16th of 2020 through February 15th of 2023 in the city of Adrian and the county of Lenawee, that you did commit the offense of criminal sexual conduct, 4th degree incest. Guilty or not guilty?
Zero.
All right. And how do you wish to plead to count 4, that during the time period of December 16th of 2020 through February 15th of 2023 in the city of Adrian and the county of Lenawee, that you did commit the offense again listed under count 4, criminal sexual conduct, 4th degree incest? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, yeah.
Is the do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Sure.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Dagger Margosian?
No.
Ms. McClure?
None, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Dagger Margosian, I can inquire, or do you wish to voir dire your client?
Your Honor, I'll what? Mr. Kapnick, on between the date range that the court listed, December 16th, 2020 and February 15th, 2023, were you in the city of Adrian, county of Lenawee, state of Michigan?
Oh, yes, sir.
I'm sorry, you gotta speak loudly for us.
Yes, sir.
Okay, thank you.
And in that date range, did you have sexual contact with an individual with the initials of AK?
Yes, sir.
Speak louder for us.
Yes, sir.
And was there a familial relationship between the two of you? In other words, was that a father-daughter relationship?
Yes, sir.
And that sexual contact was unconsented to, correct?
Yes, sir.
And you would agree that the familial relationship is really the first degree of blood affinity, but in other words, it's within 3 degrees of blood affinity?
Yes, sir.
Okay. And that sexual contact happened twice in that time range, correct?
Yes, sir.
I think I'm satisfied here.
Ms. McClure, are you satisfied?
And do you agree that the individual with the initials AK was below the age of 13 and that you were greater than the age of 17?
Yes.
Okay, I'm satisfied, Judge.
All right. Has the court complied? Yes.
Satisfied, thank you.
Has the court complied with the MCR 6.302 B, C, and D? Mr. Dagger Margosian?
Yes, Your Honor.
Ms. McClure?
Yes.
Right, I accept both, the plea to both counts. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Adams, what date can I use for sentencing, please?
Judge, I have down February 21st at 8:15, if that works.
Are you available that day, Mr. Dagger Margosian?
Thank you.
All right, so we will set this for sentencing on February 21 at 8:15 in the morning. Ms. Adams, could I get a notice of hearing from Mr. Kapnick?
Okay.
All right, so Mr. Kapnick, I'm going to have you step across the hall to the probation department. It's a busy day over there today, but they will set up a time for you to come back and meet and speak with them, and also give you some paperwork to fill out. When you meet with them, be truthful about your background, be truthful with them about the events that occurred. They'll prepare a pre-sentence report that will be provided to your attorney from my office. He will get a hold of you. He always does. He's really good about it. Review it with you in advance and sentencing will probably be in person. So I'm gonna set sentencing in person. So we will see you back on February 21 at 8:15. And what are you gonna say?
I was just gonna briefly request to address bond.
Okay,
He has a GPS tether on his ankle, been on since probably the pendency of this case. There's been no violations. It is costly pursuant to him taking this plea. I guess I would ask the court to consider removing it. I don't know if there would be an objection from the people, but for the reasons stated, I think it would be appropriate.
so Ms. McClure, as I looked back through the file, I don't always get everything from district court, but it looks like his tether's been on since November of 23. Did people have any position?
I have
There's been no
position.
violations.
No,
Oh,
I
I'm
have
sorry.
no position. I would leave it in the discretion of the court.
Okay, all right, so I will allow the tether to be removed. Understand if you violate any of the bond conditions by contact or anything else, I will incarcerate you. Okay, all right, so bond conditions can be changed. Were you reporting to Mr. Coast at all?
It was, Your Honor, his name was Darren, not quite sure his last name.
Yeah.
Coast.
Yeah, okay. So I'll contact Mr. Coast, so he'll meet you in the hallway to tell you what you need to do. So step across the hall, check in. Ms. Teskey, I see is here today. You'll probably be a Chris Jones case, but they'll give you information what you need to do at this point. Make sure you show up, be honest with them, and we'll have the tether removed. All right?
Thank you, Your Honor.
Anything else? No, go ahead.
I was told about this plea and got on as soon as I was told, but I don't have any of the plea agreement information or anything.
I just chatted it to you as soon as you logged on. He
Okay.
pled guilty.
Sorry.
Out.
I was gonna say, I sent it to Mr. Jones. I can forward the email to you, Ms. Teskey.
Okay, thank
He
you.
pled guilty. He pled guilty. I chatted you. He pled guilty
Okay.
to count 3 and 4, 4th degree CSE, count 1 and 2 dismissed, no sentencing agreement.
Okay. Thank you.
Okay. All right. So here's a notice of hearing for sentencing. Remember, it's in person. And we'll see you back on that day. Thank you. Could you let Mr.
Thank you.
Coast know to go talk to him in the hall? All right. And we'll send Mr. Coast out to the hallway. Are you ready for Mr. McKenzie to be brought down?
Yes.
All right. And then I have Mr. McKenzie as well, Ms. Teskey.
Should we have?
Okay, what is he here for, Your Honor?
Not gonna be.
Evidently nothing that will concern you, just a pre-trial.
Okay. Sounds good. Thank you. If you need me, I'm here.
All right. Okay. Do you guys want to talk to me in the jury room?
I don't think it matters.
Your body language is like freaking me out on you too. So why don't we go back in the jury room? Good morning, Mr. Marguerite. Hey, Sam. Okay. Me first.
Judge.
Maybe all the time, same line, nice, big, well, so far. And I'm done now.
Please rise, sir, court's now in session. You seated.
Mr. McKenzie, you want to go up to the podium? All right, let's get the attorneys in here. Excellent. So, and Mr. Millar, if you can pull that microphone closer to Mr. McKenzie, there we go. This is in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 2024-21789FH. This is the date and time set for a pretrial conference in this matter. I have Dave McCready appearing on behalf of the Lenawee County Prosecutor's Office. And I have Salvatore Malaro appearing on behalf of Mr. McKenzie, and Mr. McKenzie is present here from the Michigan Department of Corrections. So I did take an opportunity to sit down and speak with the attorneys in this matter and review what the current plea offer is, what the current status on the case is, credit and so forth. So we have a couple things to address today. So, Mr. McKenzie, I want to go through the plea offer that was made just for the record so that I know that you fully understand it, okay?
Yes.
All right, and I'm going to need you to speak up just a little bit louder, okay?
Yes.
So, Mr. McKenzie, on this file, you are currently charged with, let me get back there, one count of home invasion first degree, which carries a maximum penalty of up to 20 years in prison. Count 2, weapons, firearms, larceny, which carries a maximum penalty of up to 5 years in prison. Count 3, weapons, firearms, possession by a felon, which carries a maximum penalty of up to 5 years in prison. Count 4, weapons, felony, firearm, which is a flat 2-year that stacks to any other prison time you serve. And Mr. McKenzie, count 1, home invasion, allows a consecutive sentence to any other counts. So for example, if you went to trial and you got convicted, count 1 could stack to count 2 and count 3. You understand that?
Yes, ma'am.
In addition to the 2-year felony firearm. So do you understand that?
Yes, ma'am.
Okay. Now, you have a habitual offender 4th offense notice, which means if you got convicted on count 1, the 20-year home invasion, count 2, the felony or the larceny of a firearm, which is a 5-year, and count 3, possession of a firearm by a felon, which is a 5-year, those 3 offenses would become life offenses.
Yes.
Okay. And because home invasion first degree could stack, you could have potentially home invasion first degree being a life offense, stacking on another life offense.
Yes.
Do you understand that?
Yes, ma'am.
Okay. Now, okay. Now the plea offer, and now there is also a warrant that potentially could be authorized for a home invasion, we think 3rd degree, that occurred in, is it December of 22 or 3?
23.
December of 23, there is potentially a pending home invasion 3rd degree. Do you understand that?
Yes, ma'am.
And my understanding from talking to Mr. McCready and Mr. Malaro is if you were to accept this plea offer, that case would not be charged. Do you understand that?
Yes.
And that case, in addition, if it were to be charged and you were to be convicted, would stack to this one because it occurred while you were on bond. Do you understand that?
Yes.
So potentially, if you went to trial, you could be facing multiple life offenses that stack. Do you understand that?
Yes, ma'am.
Okay. So the plea offer that was made is that they would not charge you with the new case and that you would plead to count 1, home invasion, first degree, with an agreement that your minimum sentence would be 72 months.
Yes.
Do you understand that?
Yes.
With credit for 24 months. So it would be, you would end up serving 4 years on that home invasion first degree. Do you understand that?
Yes.
And 1 felony firearm, which means that you would serve the 2 years on the felony firearm first. And then the 72 months with credit for 2 years on the home invasion second. So your max penalty you are looking at is 6 years. Do you understand that?
Yes, ma'am.
And as long as you didn't get in trouble in prison, you would be eligible for parole at that time.
Yes, ma'am.
All right. Do you understand all of that?
Yes.
Okay. Now, are you his mom?
Yeah.
Okay. So your mom is here in support of you today.
Yes.
So do you have any questions about that plea offer?
No, ma'am.
Okay. Do you, and I have another person in the courtroom. Is that a victim?
Just a good friend.
A good friend. Okay. So, Mr. McKenzie, I know that's a lot of information to throw at you at one time, and I know your attorney has addressed it with you. Do you need time to have a conversation with your family because they're here? No, hold on, ma'am. Hold on. I mean, you can't sit next to her. You can't do anything like that. But I could vacate the courtroom and allow her to speak from where she is to you. This is a big decision, and I respect that. So is that something you would like? Obviously, your MDOC transport would be present, but the rest of us could leave.
I don't agree with the plea agreement.
It doesn't matter if you
None
agree
that
with
would
the plea
change my
agreement.
mind on that, if that's what.
Okay, so, okay, I just wanted to know because I do offer that opportunity. So you fully understand the plea offer.
Yeah.
You don't like it. But you understand, Mr. Malaro and I have no choice in the plea offer.
Oh, no, I understand.
Okay, so you understand though, the plea offer gives you 6 years. If you get convicted, you're looking at multiple life offenses.
Yes.
Okay, so do you want to talk to your mom?
Yeah.
Briefly.
Okay, so what I'm going to do at this point, Mr. McKenzie, we will not listen in on this, but obviously MDOC transport will be here. Ma'am, you can come sit in the first row to talk to him. You can't touch each other. I'm so sorry, but you can have a conversation, okay? So what I'm going to do, and do you want Mr. Malaro here in case she has any questions?
Yeah.
Okay, so what I'm going to do is, All right, so Mr. McKenzie,
I think we need Mr. McCready.
oh, where'd he go?
Okay.
All right, so we are back on the record. Mr. McKenzie, I don't do that often, but I know when you're in the Department of Corrections, you're kind of isolated from your family. So I do allow for people who are in MDOC to have that opportunity. So Mr. Malaro and Mr. McKenzie, how do you wish to proceed today?
Your Honor, court should probably address the conflict issue that I brought to the court's attention, but before the court does that, I think Mr. McCready, since it is such a large decision, I would ask perhaps adjourn this out for him to consider this.
Of course.
If Mr. McCready would be kind enough to keep the offer open until next pretrial.
All right, Miss Adams, when is my next available pretrial? Or do you want to do it on a day other than a Wednesday?
Wednesday's fine.
Okay.
But the only thing is, Judge, it is so difficult to have contact with MDLC people that I'd ask they be here in person.
It's okay, we can set it for like 11.
Sure.
Okay. So Miss Adams, I'm looking for like a Wednesday at 11.
We have jury trials on Wednesdays. So, I don't know if you wanna add it to those days anyway.
We could do like 10:30.
How about January 22nd?
Okay.
That's fine, as long as, I'm not sure how much lead time I need to get him back.
A week.
Okay, so that would be fine.
All right, so I'm gonna set this for January 22nd and we'll do 10:30. That should give you time, Mr. Malaro, to get. Okay, so January 22nd of 25 at 10:30 a.m. And that'll be in person. So the prosecutor's office will do a writ. And all right, so Ms. Adams, if you would like to get a copy from Mr. McKenzie. Well, I guess all of them are sitting here. All right, so next we need to move on to a potential conflict. So in a small county, we have a limited number of public defenders. And sometimes it comes to our attention, not mine, but to the public defender's attention that potentially a co-defendant may be represented by another attorney through the public defender's office. And Mr. Malaro did his due diligence and realized that. And so obviously, Mr. Malaro, you wish to make a statement about that?
Yes, Judge. So when it became clear to me that one of the state's main witnesses is also a defendant ongoing case with Mr. Murphy, I explained to Mr. McKenzie that's a conflict and that he could waive the conflict. I didn't discuss with him that possibility. I think that's something probably more for the court to do.
Okay.
So, I mean, he can certainly waive it. I would remain as his counsel. I'd probably take all precautions and maybe even contact Mr. Murphy about his case being conflicted out. I know this just came to my attention today when we were discussing this case. I have no preference either way. Clearly, Mr. McKenzie's decision.
Okay.
If in fact he wants to be conflicted out of our office, we would refer him to the conflict attorney, Mr. Castleberry, who would then assign the attorneys that are on this conflict list. And I think he does it.
Okay. So, Mr. McKenzie, do you understand your attorney explained that to you?
Yes, ma'am.
And caution wise in these circumstances, Mr. Malaro, I think it's that you never view the other file They never review your file and there's no communications regarding the case that goes to MDOC and to them. So, Mr. McKenzie, would you like a conflict attorney?
Yes, ma'am.
Okay, so he's not going to waive that. So what we will do is, we will, send notice to, does your office send notice to Mr. Castleberry?
Just we notify the office manager, she notifies. me.
Okay. So notice will be sent over. It takes a little bit of time. The file will have to make its way over to that attorney's office, whoever gets the appointment. We don't know who that is, and they'll be here the 22nd.
Yeah, it'll probably be assigned later today. I don't know when that attorney will pick it up and it'll probably be assigned later today.
So understand there might be a chance you don't speak with them before the next court date. Okay,
Thank you.
all right, so very good. And your office will do the paperwork. Is there anything else we need to address today?
Not from the people.
All right, thank you all. Thank you, Mr. McKenzie, and that concludes this hearing.
Thank you.